Good afternoon, everybody. My name is Nancy Delaine, and let me share my screen with you. I will be presenting this delightful little piece of information to you this afternoon. And we go to show on the start. Okay. Topic of today's continuing legal ed from the Schenectady County Bar Association is intellectual property. Whether or not to dabble in intellectual property, and I'll give you a couple of how-to demos in case you decide that dabbling would be a good idea. A little bit about me. My name is Nancy Delaine. I was admitted in New York in 2004 and before the US Patent and Trademark Office in 2005. So I've been doing this for a little while, probably not as long as everybody here, but at least for a little while. My practice areas are patent law. I also handle soft intellectual property and business law. In my pre-lawyer life, and I did have a pre-lawyer life, I spent 20 years as a technical documentation person, meaning that if you've ever put a child's bicycle together on Christmas Eve, some technical writer did that to you, and that may have been me. Sorry about that. Before that, I also spent 2 years in a virology lab. My JD is from Franklin Pierce Law Center in 2003. Franklin Pierce has since gotten eaten by the University of New Hampshire. My master's is from RPI. That was in 1981. And way back in the nether reaches of time, 1978, I got my bachelor's degree at Smith College. So let's start a little bit of Intellectual Property 101, and we'll start with patent. Patents protect invention. They come in 3 varieties. There's the utility patent, which is what we all think of when we think of a patent, okay? It's the better mousetrap. It's the process. It's the procedure. It's the gizmo. And that's what we all think of when we think of patents. There's also such a thing as a design patent. And a design patent is just that. It's a design. And the claim in that patent, it has one claim. And the claim is the drawings. The drawings are a top, bottom, and 4-sided view of whatever it is you've got an ornamental design for. There's also a plant patent, which covers the invention of non-tuber asexually propagated plants. You cannot patent a potato. Do not ask me why. Patent law is exclusively federal jurisdiction. It's covered under 35 United States Code, which is interpreted by the Code of Federal Regulations at 37 CFR. And then that is further digested by the Manual of Patent Examination and Procedure, which is a book that is, the last time I saw it printed, it was about 3 inches thick on onion skin paper. It's a horrible document. Then there's copyright. Copyright protects works of authorship, which include literary works, musical works, dramatic works, artistic works, and architectural works. It does not protect taglines or slogans. It too is exclusively federal. It's governed under Title 17 of the United States Code and also under 37 CFR. Trademarks and service marks protect business goodwill. These are your slogans and your taglines. You're also logos. And if you look at the upper left-hand corner of your screen, you will see a logo in use as a trademark. Okay, logos can be visual, such as the one that's on your screen. They can also appeal to just about any sense. For example, the scent of Chanel No. 5 is a registered trademark, as is the color of Chemlon Green and the NBC chimes, and you all know those. Bing, bing, bing. Trademarks are hybrid creatures, bless their darling little hearts. They are covered both federally under the Commerce Act, 15 U.S.C. 1051, if you want to be that specific. And also under 37 CFR. They are also governed by state law, and every state has a trademark law. In New York, that's in the general business law, and it's not consecutive. Isn't that sweet of it? It's 360, 390, 392, and the list goes on. It's really too numerous to list. Does anybody know what, if anything, is the difference between a trademark and a service mark? Dead silence. A trademark is used for goods. A service mark is used for services. Otherwise, they are interchangeable. And if you're saying to yourself, I didn't know that, this is not the place for you to dabble. Patents. Patent law involves several things. It involves the transactional bit, where you're drafting the application and developing the application. You're filing that application. You're prosecuting that application. You're maintaining that patent. In other words, you're working before the United States Patent and Trademark Office. You need to leave this to the patent lawyer. In order to work before the USPTO, you have to be admitted to practice before the USPTO. And admission before the USPTO requires not only passing the patent bar exam, but you also have to have an undergraduate degree in a hard science, physics, chemistry. Mine is biology. Computer science, math, engineering, they love, but something that has to do with applied science. Anybody can litigate a patent, but I would still send this to the patent litigator, who may or may not be admitted before the US Patent and Trademark Office, mostly because there are piles of money. I mean, we're talking multi-million-dollar litigation. And if you do choose to litigate a patent yourself, and you need to be, if you're admitted before any federal district court, you can litigate a patent. Be sure you check your errors and omissions insurance policy to be sure you're covered. I can tell you that starting out as a solo intellectual property attorney, I had one devil of a time trying to find an E&O policy to cover my practice. I finally did, but nobody covers this stuff. So be careful and be sure you check that policy very carefully before you even think about dabbling in intellectual property, because the stakes are high and the lawyer litigation is higher. Soft IP is copyright and trademark. And again, if you choose to work in this area, make sure your E&O insurance covers it. As I said, E&O insurance to cover this stuff, it's a rider on many firm policies. And it would cover registration, it would cover litigation of this particular subject matter, but it adds to your insurance cost. Trust me, trust me, it adds to your insurance cost. Okay, so just for the fun of it, let's run through a sample registration for copyright. And I give you a picture here of the work that's being registered. This is a melding of two photographs that I took back in 2016, and I decided to register this just to have the registration. Okay, so we start off at eco.copyright.gov, which is the copyright, the electronic copyright office. You have a user ID, you have a password. If you're a new user, you need to register for a user ID and a password. It's free, you can do it. You register like you do any other login system. Once you log in, it welcomes you. Isn't that nice of it? And it tells you if you have any open cases. Now, by the time I took this picture, I had already opened the case for the photograph. So it tells me that I have an open case, and it gives it a long number, and it tells me the date it was opened. It tells me the title of the work. It tells me what type of work it is. Tells me what application format it is. Tells me how much I paid. And then it gives me a bunch of notices, which are important for people to read. It tells you that you can register up to 10 unpublished works in the same application. So if you have 10 unpublished works, or up to 10 unpublished works, you can list them all and pay the same $65 fee. And the Copyright Office is very kind. They give videos for just about every step in this. You can't register a collection this way. there's a special registration to register collections. And you need to know the difference between 10 unpublished works and a collection of unpublished works, because sometimes that difference, sometimes that line is pretty vague, okay? There's a book out by J.D. Salinger called From Esme with Love and Squalor, and it's a collection of short stories, and each short story stands on its own. And the question became for that copyright lawyer, I'm sure, is this a collection or is this separate unpublished works? And as it turns out, the book is published as a collection, so presumably it was registered as a collection. But I'm sure that Mr. Salinger and his attorney went back and forth a few times about that. When you first register the work, the first question that asks you is, what type of work is it? It gives you a choice. You can register a work in the visual arts, which is what this one is. You can register a literary work, which would be a poem, a short story, a novel. You can register a musical work, which would be music. You can register a dramatic work, which would be a play script or a movie script. You can register the finished movie, which is a work in motion pictures and audiovisual. You can register just about any work of authorship. The question is, where does it fit? And that question arises often with registering music when you have lyrics. Is it a musical work with words, or is it words set to music? And it makes a difference as to which one you register. Okay. You click on continue. You enter the title of the work. This is the blank screen where you enter the title of the work. In order to enter a title, you click on new, and it gives you a screen that lets you enter the title of the work, and you have a choice between title of the work being registered. You can register it as a working title. You can register it as a collection title. There are several types of title that you can do. I chose the title of the work being registered, and I entered Dandelions, and I clicked on continue, and it brought me back to this screen. If I have more than one work that I'm registering, I would again click on new and just repeat the process. Okay, I then have to tell the Copyright Office whether or not this work is published. Now, what does publication mean? Once again, it gets fuzzy, especially with the internet. If somebody posts a picture on Facebook, is that publication? If somebody prints, get your tail out of the way, Jazz. If somebody prints a work and distributes it to their family and friends, is that publication? Clearly, if you print a work and you post it up on Amazon for sale, that's publication. But there's a lot of gray area in between there. So it's important to know what constitutes publication and what does not. Okay, in this particular case, I put yes for my work just to show you the screen. The work has actually not been published, but I completed it in 2016. I have no idea what date I first published it, so I put the last day of the year of the year of creation. The nation of first publication, usually for US copyright, it's the United States, but it can be anywhere else in the world. If it has an international standard number, you'd select that type and you'd enter what that number is. And if you pre-registered this work and received a pre-registration certificate from the Copyright Office, you would enter the pre-registration number here. Then you would click continue. But let's do this and do it right, and put no as the answer to the question. All you need to do then is tell the Copyright Office when the work was completed and again, if you have that pre-registration number, you need to put that in. You then list the authors, and you can add yourself as an author. Since I was the author here, I added myself, although, hello, there we go. Although the system did not pick up on my organization or my citizenship or my domicile, but you have to supply you have to supply either the name of an individual or an organization to register a copyright. A work made for hire, if you are paid by somebody to complete a work of authorship, then that would be a work made for hire. The contract must say this is a work made for hire. And then when the owner of the work goes to register, they will still list you as the author, but they will put, yes, this is a work made for hire, and they will they'll have to produce documentation of that. You need to supply your citizenship. You need to supply your domicile. I usually do both. It's either or. You also have to tell the copyright office whether the work is anonymous or pseudonymous, and if it's pseudonymous, you provide your pseudonym. You tell the author's year of birth, and if it applies, you tell the author's year of death. Come on, baby. Okay, so here it is filled in. I'm in the United States. This is not a work made for hire. I selected citizenship rather than domicile. My year of birth is 1956. It's not anonymous or synonymous. And I'm still alive, so I haven't died yet, so I don't have to put that date in. Then you tell the Copyright Office what the author created. In this case, I created a photograph, and I haven't checked the box here yet, but I created the photograph. It could be 2D artwork. It could be a jewelry design. It could be a sculpture. It could be a map. It could be an architectural work. It could be technical drawings, or anything else that the author created. Okay, let's see. There we go. And it comes back and it lists me as the author, and it tells the Copyright Office this is the name of the author. The copyright claimant may be different from the author. For example, if you work for, I spent many years working in the computer industry and for places like GE and 3M, and I did a little work for IBM. They don't really count. But let's pick General Electric Company just for the fun of it. Say I had created a document for a piece of General Electric software, which is not actually incorrect. I did. General Electric would then register that work, listing me as the author, but I don't have any claim and copyright for that. So they would list themselves as the copyright claimant. They would do that by clicking on the new button, and they would list themselves. Here, I'm the copyright claimant, so I list myself as the claimant. Oops, go back. This is where you have to document that you have a transfer, and tell if the author is not the claimant, you have to tell how the claimant has the copyrights, has the right to claim the copyright. Okay, then you get to limit your copyright claim. If, for example, I'm sitting here showing you U.S. government screens, okay? They happen to be sitting on a PowerPoint that I created, but the screens belong to the U.S. government. So I would exclude all the I would exclude the graphic that is the screen if I were registering this. And I would explain what I included that's new, whether it's artwork or photograph or whatever. In my case, I'm not really contributing anything new except for the stuff at the front of the presentation. You then have to tell the Copyright Office who they're going to correspond with, and regarding copyright management information, whether if somebody wants to license the rights to use the copyright. So I add myself to this. I always add myself to this, whether I'm registering for a client or whether I'm registering for myself. And I hit the continue button, and we move on to the correspondent. This is the person with whom the Copyright Office will correspond regarding the registration. Should they have questions, and they often do. Should they have questions, or this is also where they'll send the certificate of registration. No, it's not. I lied. You tell the Copyright Office where to mail the certificate. You can have it mailed directly to the author. You can have it mailed directly to you. I tend to keep copyright certificates, send the author a copy, because if the copyright ever comes under litigation, I want the copyright certificate to be readily available. And if I hand it to an author, it probably won't be. So I have the office send it directly to me. Special handling. Do not, unless there's a very good reason, submit for special handling. Special handling is, as the red text says, very, very expensive. It's somewhere around $1,000 to file this. But you give, there are a couple of reasons to do it. If there's pending litigation and you need the certificate tomorrow, then yeah. Have the client pay for the special handling. If it's a customs matter, yeah, have the client pay for special handling. If there is a contract or some kind of publishing deadline that necessitates the expedited issuance of the certificate, yeah. And they ask you to, you don't have to, provide some kind of explanation for why you're looking for this special handling. I have always found it very useful. I've never done a special handling certificate, but I have always found, I have clients who are, 80, 85. I have one 92-year-old who regularly registers copyright. And I have always found it very useful in this page, which is the certification page. I can send the Copyright Office a note that says, while this does not require special handling, this client is 92 years old, and we would really appreciate her being able to have her certificate in hand before she leaves this earth. And the Copyright Office is cooperative with that. They really are. They don't expedite it, but they don't delay it either. Then you get to review this submission, and you have the opportunity to go in and make any changes you need to make. The next step is to pay for it, and you added it to your cart, and you can add more services to the cart if you want to, or you can hit the checkout button. In this particular case, I just have this one certificate this one work to register, and so I hit the checkout button, and it asks me how I want to pay for it. I can pay for it with a deposit account with the Copyright Office, which large firms tend to have. Solos like me tend not to have them, so I pay it with a credit card or an ACH payment. And I hit pay by credit card. I'm not going to produce my credit card number for public consumption, but it looks like a credit card screen. Name, billing address, credit expiration date, the CVV number. It looks like a credit card screen. So in my particular case, my payment was successful. Yay! Bank still likes me. I paid the Copyright Office $65. I print this screen out to keep it for client expense purposes. so that the IRS doesn't dun me for the $65 that my client paid me to pay this to pay for this registration. I then click on continue, and I get to the page where I actually have to submit the work. Okay, in this particular case, I'm going to submit it electronically, and so I list it, and it lists the file, and dandelion reg with copyright office .jpg. It'll take JPG and PDFs, and once I have submitted it, once I hit the submit button on this thing, it submits it, and we're good. Or alternatively, I can send my work by regular mail. I need to produce 2 copies of the work, and attach the shipping slip. Okay, here's the attachment name, and attach the shipping slip. Electronic copies are not always acceptable. Okay, if the work is unpublished, it's acceptable. This is why it's a big deal as to whether a work is published or not published. Okay, if a work is published only electronically, even if you go to Amazon, if you do your book as an ebook, you can still register this work electronically. If you have a published work for which the deposit requirement is identifying material, you can publish it electronically. Or if there's some kind of special agreement that requires a hard copy deposit where you're sending separately to the Library of Congress, yeah, they'll let you do it, but you have to follow that up with the hard copy sent to the Library of Congress. You can always use the electronic system to register the work and to pay for the work, but the work will not, the registration date will be the date that the work is received by the Copyright Office. It won't be the date that you filed the electronic stuff. Here's the Copyright Office receipt, and it is the shipping label. You fill this out. You fill it out with the quantity and the number of the quantity and the format of the work that you're sending. For example, if I were to mail my picture in, I would put quantity 2, format photograph, and I would mail it to the Library of Congress Copyright Office, and they give the address at the bottom of the shipping slip. You need to attach a copy of this shipping slip to each and every copy of the work that you send. So, I heartily recommend making a PDF of it and just printing it out over and over and over and over and over again. Next steps, you wait. Sometimes you wait a very long time. The very first copyright I registered was for my daughter, and I filed the registration when I was a second semester 1L. I didn't hear back from the Copyright Office until right before I graduated from law school. Okay, they responded with a certificate, but they sometimes respond with questions. And if you don't understand a question, feel free to call in the expert. If they're coming up with something about originality, if they're coming up with something about some kind of format issue, with your registration, call in the expert. It's time to call in the expert. Okay. After the objection is overcome, the next step is they'll issue their certificate. They'll send it out to the mailing address that you provided in the application. I'm going to unshare my screen for a minute here and see if anybody has any questions about copyright, about anything we've talked about. Okay, I'm going to reshare my screen and proceed. Okay. Another place that people who don't regularly practice intellectual property law like to dabble is in trademark registration. So let's walk through registration just for the fun of it. Oops. Okay, we started the U.S. Patent and Trademark Office's website, www.uspto.gov. This website is a plethora of information. It is one of the best websites on the internet. So if you have any intention in dabbling in any intellectual property, visit uspto.gov and read the website. It is marvelous. It's even written so that human beings can understand it. Their find it fast thing, well, that's a misnomer, but the information is all there, and it is inclusive, it is thorough, it is clear, it is, and if something's not clear, call them up and ask them about it. They are really good about answering that kind of question. Okay, to apply for a trademark, you apply online for a trademark. You can file by paper, but it is expensive. Trademark registration costs a minimum of $225 per mark per class. If you file in paper, it's $600 per mark per class. Your client's not going to appreciate that difference, so apply online. You file using the. I would spend some time looking at the basic information before filing if you've not done this before. You can take a look at the index of all the T's, of all the trademark electronic application system, TEAS forms. And the ones you want are obviously the initial application forms for an initial application. Before it'll even show you a form, it asks you to, it asks you where you're registering. Are you registering on are you using a standard form to register? Are you using are you applying on the so-called supplemental register? Are you registering for a certification, a collective trademark? So you need to have a little chat with your client to understand which application you need to file. Then you've decided which application you're going to file, and it still comes up with you have a choice. I'm filing an initial application form, and I'm giving it I'm going to apply as TEAS Plus at $225 per class of goods and services, and I will, if I'm ready to apply, I will click on Start the Application. And this is the screen I see. Whoops, sorry. This is the screen I see. Come on, baby. There we go. This is the screen I see. There are a bunch of questions that the Trademark Office will ask you. You can always get help. And you need to understand that nothing that you pay to the government is refundable. This is the government. The U.S. Patent and Trademark Office is a profit center for the government, and they will not refund any fees that you pay. Okay. If you are new to this, even if you've done it many times, I would still spend a little time on the trademark basics for information about the filing process. There is a tutorial. If you need help, they give you an email address, they give you a phone number. Feel free to use them both. If you need help in using the forms, or if you've got a technical problem with the form, They give you an email address. They want your phone number so that they can call you, and they will call you. They're very good about that. If you've got a serial number, they're going to want that, or a registration number for the mark. You can give them a bug report. After you have filed your application, the system will assign it a serial number. You can always check to see where that application is standing. So I have a choice here. It's either a T's plus or a T's, and I'm registering it as a T's plus. There are T's plus requirements. You can click on the link there to learn what those T's plus requirements are. If you do not follow those requirements, you will incur an additional $125 per mark per class. Okay, as opposed to just registering it now as a T standard, where it's only a $50 difference. So be careful as to how you're registering. Okay. If you're an attorney filing the application, yes, it will. What this will do is it will put in attorney information fields into the application. If you click on no, it will not put in attorney application fields. So I left it as yes. I didn't have a previous file to upload, so I just clicked on continue, and this is what I saw. Okay. In this case, the owner of the mark is test subject. Test subject is an individual. Okay, and test subject lives at 123 Main Street in Anytown, New York, United States, 12345, which, in case you didn't know it, is the actual zip code for the GE plant in Schenectady. If you register your company as a corporation or an LLC, the question's a little bit different. It wants to know the jurisdiction in which the entity is legally organized. Okay. It wants to know information about the trademark. Okay. It needs to, your mark has to be clear. You need to use either standard characters, or you need to give it a special form. Something like the image on my slides would be a special form, whereas the tagline, "Nurture your mind, child," that's just standard characters. Okay. You click on one of the three circles. You click on one of these three circles to load standard characters, stylized and/or design, or a sound mark. You name you give it the you tell the trademark office what the standard characters are. I usually preview the USPTO generated image. That's what it looks like. And then I hit continue. And this brings me to the selection of goods and services, where you tell the trademark office which class, which stream of commerce your client intends to use the mark in. Okay, and you add goods and services. In this particular case, I just did a search on toys, just to pick a word. Okay, it came up with 376 entries for toys. Okay, so now I have to be a little more specific. I have to tell the USPTO whether I'm talking about sex toys, or baby toys, or musical toys, or sketching toys, or air pistols, which are weapons, not toys, or air rifles, which are weapons, not toys, or rope for use in pet toys, or miniature electric motors for toys. So I have to be much more specific than just toys. In my case, I'm planning on registering this mark in 4 classes. Okay, class 13 is air rifles, which is weapons, not toys. Class 22 is rope for use in pet toys. Class 7 is miniature electric motors for toys, and class 28 is infant action crib toys. And you'll see why I'm doing that in just a moment. Okay, so I have now my 4 things, and I need to assign a filing basis. Okay, so I click on the first one. And I'm going to assign that to section 1A. which is use in commerce. The mark is currently being used to market miniature electronic motors for toys in the stream of interstate, not intrastate, interstate commerce. Okay, I have to attach a specimen to show the U.S. Patent and Trademark Office. So I actually just gave it the logo there, the brain there, and so I attach my logo, and I click on attach, so it actually does attach, and it takes me back, and now I have an attached specimen, and I describe it. So I'm using test case. So the date the mark was first used was August 10th, which was yesterday. The date first used in commerce was August 10th, yesterday. And I click on assign filing basis. And as you can see, there is a 1A over here next to miniature electric motors for toys. I then select the next class, and this one I'm going to register as a class 1B, which is the mark is not yet being used in commerce. Okay, you're planning on using it, and I click on section 1B, comes up with a description of it. The applicant has a bona fide intention and is entitled to use the mark in commerce in connection with the identified goods and services. Okay. Okay, and you have to click on this little button here to acknowledge to the Trademark Office that you understand that a 1B application has additional requirements. Okay, you have to begin using the mark in commerce, and you have to file an allegation of use that includes a specimen and an additional fee. The U.S. Patent and Trademark Office is a profit center for the government. And even if the mark is approved, after you file that allegation of use, you get a touch-up examination, and it may be denied. So 1B is kind of a risky thing to have your client do. I click on assign filing basis. You don't have to produce a specimen this time because you've just told the office there's no specimen to produce. So it simply assigns the 1B filing basis. Next time I'm going to click on rope for use in pet toys. I'm going to do a 44D application, which is a foreign application exists for these same goods and services. So I've registered, I've applied for registration in Canada or the EU or India or Japan or wherever. I have to tell the office where I've applied for the Section 44D plan. In this case, Australia's at the top of the alphabet. I just picked Australia. I gave it some random filing number. I told it, and I didn't change this because the date for foreign filing must be within 6 months. I actually got an error message when I hit the assign filing basis for this, so I changed it to 7/10, you have to tell the office whether you intend to rely only on Section 44E as a basis requirement, or if you have another basis. For example, a 1A. You're already using it in commerce in the United States. You click on assign filing basis, and hey, guess what? Hey, presto! There you go. You've assigned the filing basis. Section 44E, we're going to assign that to class 28 here, and this is based on foreign registration. The mark is actually you've applied for the mark, and the foreign registration is actually issued, and you intend to use the mark in commerce in the United States. So again, I've got Australia. I entered a random number. I put in the foreign registration date. I put in the expiration date of the foreign registration. I attached a copy of the foreign registration, and If, for example, I'm registering in a place like China or Japan or Korea where they use a non-Arabic alphabet, I would have to include a claim of standard characters in the country of origin. Okay. I upload a copy of the registration, and I click on attach, and I click on return to form, and then I click on assign filing basis, and there we go. We've got a 44E registration. I then click on continue, and now we're getting into the attorney information, which is okay. So I put my own name. It wants your year of admission. It wants to know where you're admitted. It wants your membership number. It wants to know where your office is. It wants to know your email address. It will use the office will use this email address to correspond about this mark with anybody who says that yes, they used an attorney to register. If you chose at the very beginning that no, you're not using an attorney, you would obviously skip this page. Okay. And then I would click on continue, and this gives me a chance to have other people receive courtesy copies. However, it is my address that is the only address that the office will correspond to. They will send courtesy copies to other people. So I have them send one to the paralegal. I have them send one to some other attorney, whether that's opposing counsel or somebody else in the firm. I might have them send courtesy copies to the client. I can enter up to four addresses, and then I click on continue. I have 4 classes here at $225 per class. That would cost me $900. If I proceeded beyond this page, I would be on the hook for $900. So I'm not going to proceed beyond this page. However, I will show you what the signature looks like. Okay, you have to state that you believe that the applicant is the owner of the mark, and the mark is in use in commerce, and the specimen was used as of the date the application is filed, and the facts recited in the application are accurate. You have to say there are no concurrent users to the best of your knowledge. You have to say that to the best of your knowledge, all of the allegations you've made above have evidentiary support, and you are being warned that if you knowingly make a fraudulent statement, then hey, guess what? That's like criminal action, and you don't want to do that. You sign your name. You use whatever. Once you hit the you use whatever form you want to sign your name. I use my initials there, but it does want the slashes around your name. It gets very upset if you don't provide those. You give it the date signed. Actually, the system fills in the date for you, which is very nice of it. You tell it your name. You tell it what your relation to the mark is. Okay. In my case, I'm the attorney of record, New York bar member, and it wants my telephone number. So I give it all those things, and I can validate all that and pay my fee. I'm not going to do that because I don't want to be $900 in the hole on this. So that is some of the complications of filing a copyright and filing a trademark application. The big complication for people who want to dabble is make sure your E&O covers this area of law. There is, if it doesn't, then trust me, your E&O insurance will say, oops, sorry, we're not paying that claim. And there goes your house, there goes your car, there goes your firstborn child. So make sure that your if you do intend to dabble, make sure that your E&O insurance knows about it and covers it. Don't try and pull a fast one with don't try and pull a fast one with your insurance company on this. The stakes are far too high. I'm going to unshare my screen at this point. Let's see. Stop share. And ask if anybody has any questions. And Meg, I apologize to you because I didn't even see that you were knocking to get in. But I can tell you that I've made a recording of the entire performance, and it'll be available on my website. And that, unless there are any questions, that's pretty much all I have to say.
Thank you, Nancy. We do welcome questions. Nancy, we'll also perhaps get a set of the slides that we can then share with the
Oh, absolutely.
Yeah.
I'll email them to you, Beth.
Yeah, because what I'll be doing is sending out an evaluation, and it's our standard evaluation. Subject to it doesn't talk about the physical facilities and those sort of things. Once you return that, I'll then email you your CLE certificate, but it will also include the set of slides from Nancy. So any questions for Nancy here? You know, Nancy, there's also, I think before you embark on a trademark or something like that, do you standardly conduct a kind of a search process for your clients?
Not just kind of a search process. I charge a pile of money for that search process.
Yes, yeah, because that often then precludes, you know, sometimes you don't get to the next step if you find there's a bunch of whatever.
Yeah, people fall in love with their names, and I have more than once had to say, find another name to a client. And that client gets all upset with me, and you know, sorry, the name is taken. You can't have it. So yes, I always recommend a trademark search. And hi Meg.
I am so sorry. I had it on the calendar for the wrong time.
Oh, well, as I said, I recorded the whole thing, and I'll have it available on my website.
Thank you.
So,
Nancy, could you launch the poll just for, and
sure,
this is
absolutely.
a poll merely to satisfy your MCLE attendance requirement there. So if you could just answer this one question there.
So launch poll, there you go. So far we have 4 people. You and I are not going to vote, so I think we've got everybody. So I'm going to go ahead and end the poll.
Okay, that's fine.
Yeah. And I wasn't doing it for the credit. I really wanted to hear it. So,
well, as I say, Meg, it will be available on my website.
Yeah. Well, I wanted Beth and I are working together on the real estate committee, and I also wanted to see how it worked too. But hopefully, it did work well.
Zoom is God's gift to lockdown. Let me tell you. I'm going to stop recording at this point.